Good morning, everyone. Thank you for attending the Healthicity Compliance presentation, The Consequences of Poor Incident Management. My name is Justin Larson, and I'll be our facilitator today. A couple of items to mention before we begin. Today's webinar will be about 45 minutes, followed by a Q&A session. Your line is muted, so if you have questions, please send them via the questions box, or feel free to email your questions after the presentation. Please note that there will not be any CEUs issued for today's webinar. Also, we will be emailing everyone after the presentation with links to the webinar recording and the presentation slide deck so that you can download it. Our presenter today is CJ Wolf. CJ is a healthcare professional with more than 20 years of experience in hospital revenue cycle management, practice management, compliance, coding, billing, and client services. He has been providing healthcare consulting and solution services to hospitals and physician organizations throughout the country. And I'll turn it over to CJ now.
Thank you, Justin, and thank you all for joining today. I think we've got an interesting topic, so let's jump right into it. And I think before we get into some of the details, let's set the environment a little bit and just take a step back and remind all of ourselves the whole reason why we have compliance programs. Sometimes we get so bogged down in the details that we forget the ultimate purpose. And the OIG reminds us of that here. They say fundamentally, compliance efforts are designed to establish a culture that promotes prevention, detection, and resolution of instances of conduct that do not conform to the laws, essentially. And the phrase I really want to focus in on there is that compliance programs are designed to promote prevention, but also detection and resolution of instances. So what we're going to talk about today is that detection and resolution. It does not make sense to have a compliance program if you don't believe that you're going to detect some areas of missteps and then resolve those. That's what determines whether your compliance program is effective. So as we break that concept down further, there's four main areas we're going to discuss today. And these really follow in chronologically. These are the steps that we take as we're doing incident management. The first is discovery, of course. And we're talk about the different types of discovery, and we're not talking legal discovery. I know there may be some folks with legal backgrounds. We're not talking about legal discovery. We're really talking about discovery of incidents. Then once you've discovered something, how do you go about determining even if you need an investigation and what are best practices with investigations? Then the actual corrective action, and then finally, to make sure that all of these steps can demonstrate the effectiveness of your compliance program, it needs to be documented well. Because a lot of times the issues are raised many years after the fact. So if you're investigated, frequently the issues that are investigated go back in time many years. Well, you might not have the same people on staff who worked on that case or that file. So you want to make sure the documentation is also very thorough. So first, let's talk a little bit again about some background issues. I'm going to share three examples, two that are not so great, and one that is a better example, and we're going to use that example throughout the presentation. First of all, we need to make sure we're taking incidents seriously. Some statistics here from some surveys. Not everyone who reports internally, meaning reporting an incident internally in your organization, chooses to report externally. Only 20% of people do report externally. That really gives compliance programs a leg up. If you have a compliance program, it's kind of like that movie, Field of Dreams. If you build it, they will come. If you build your compliance program, incidents are going to come. That's okay. I talk to some people and say, how's your compliance program going? Oh, great, we haven't had any incidents. Well, that actually makes me nervous because none of us is perfect. No organization is perfect. You're going to have mistakes and missteps. You need to find those incidents. Also, the second point here, a very small percentage of employees, only 8%, choose to first report any wrongdoing externally. So most individuals who want to report some sort of wrongdoing or maybe a misstep, they do so internally. Very, very few go straight outside the organization to an enforcement agency such as the government. That's very rare. And so our final point here is that if you have a good compliance program, you're going to hear of incidents, and it's a great opportunity for you to document and to demonstrate that your compliance program is effective. So let's go with a couple examples that were not necessarily the best way to do it. First, this settlement was with a medical center. It was for almost $1 million, $840,000 settlement. The allegations here, just to kind of give you in a nutshell, was a physician who was not qualified to perform stent placements, essentially endovascular procedures, procedures that are typically done by cardiologists and interventional radiologists. This particular physician was a surgeon and did not have the requisite training to do these kinds of procedures. Patients suffered some injuries and one patient died. And the key here, the reason I'm sharing this example with you, is many of the nurses who were working with this physician reported over many, many months their concerns. So these nurses are very experienced, and some of you may even be a cath lab nurse, these catheterization labs where cardiologists do a lot of their work. These nurses are excellent. They have a lot of experience. They know what catheters are typically used, what guide wires, and they were complaining that the doctor didn't know the name of the catheters. He was sometimes asking the nurses what catheter is usually the best to use and this sort of thing. And the nurses saw patients being injured, and they were very concerned. So one of the nurses eventually becomes the whistleblower and files this civil lawsuit, and that led to the settlement. But if you read the court documents, it wasn't just one nurse who was complaining, and there's records of that one nurse as well as all the other nurses who complained to many people, including the CEO, the COO, the Chief Operating Officer, the manager of the cath lab, other physicians, and even the legal department. Two nurses went to the legal department and said, "I'm worried about my nursing license." And the legal department said, "You don't need to worry. Your nursing licenses aren't going to be at risk, and the hospital has insurance to cover your personal liability." So, but you can see as you go through if you go back in time and look through these records, you can see multiple people were raising the same concern to multiple other people in the organization, to leadership, legal, all these different, and they even, the hospital even eventually had a quality review performed by an external clinician, and a written report is included in the court records showing that reviewer had concerns with this particular physician and his ability to perform these procedures. So over many months, many people were complaining and essentially reporting incidents. Those should have been tracked. Those should have gotten into a compliance program so they could have been tracked and resolved. And hopefully that would have led to a better outcome. The second example, so that example was from a hospital system. The second example is from a physician practice. This physician recently settled for a little over $7 million. Unfortunately, a 3-year exclusion from the federal health care programs and a 3-year integrity agreement. In this case, the cardiologist was performing more procedures than needed to be performed, in a nutshell, were the allegations. The whistleblower, there were actually 2 whistleblowers, and they actually combined the case into one. The first whistleblower was a physician. The second whistleblower was a biller. And this medical practice hired a billing company. The billing company comes in, and this particular whistleblower within a few short months recognized that the physician was performing more procedures than needed. She was hearing from nurses and other employee staff members with concerns. They had meetings with the physician to express their concerns, and even their attorney, so this is a third-party billing company, that company had their attorney send a letter to the physician. So there was a trail of documentation showing the concerns. What ended up happening is the physician's practice fired that billing company, and they just said, we'll just do the billing internally. So again, here was some concerns, an incident being raised, and the powers that be, the decision makers said, we're going to ignore that concern and we're going to proceed in another direction. Well, unfortunately for this practice, it led to some serious consequences. So let's turn to some more pleasant news, maybe pleasant. It was still a misstep, but in this example, and this is the example that we're going to follow throughout the rest of the presentation, you'll see we're going to apply the concepts of discovery, investigation, corrective action, and we're going to share some details of this actual case. But this was a hospital, Lady of Lourdes Memorial Hospital, and you can see here that their settlement, they did settle for $3.37 million, but as you read the records, that's a lot lower than what it could have been. Okay, if you have a billing error, you do have to pay it back. It's not like when you self-disclose, they're like, oh, okay, we paid you too much, fine, you don't need to worry about it. So you do have to pay back the errors, but what we're trying to avoid is prolonged investigations where you have to hire outside legal counsel and it goes on for years, and that can double and sometimes triple. You spend more on the investigation, the headache, the lost man hours that are devoted to an issue like this as opposed to devoted to patient care. So it's just very disruptive, as we know. But in this example, the government actually praised the hospital. They said today's settlement's an excellent example of how voluntary self-disclosure benefits the integrity of healthcare programs and providers who discover and report evidence of improper billing. So this was a billing issue. Lourdes should be commended for the manner in which it handled the disclosure. So you don't see these kinds of accolades very much from the government. So I think looking at this case can teach us a little bit about how to manage this or do incident management in the right way. So let's jump in to the four main areas that we're going to talk about. The first is discovery. So some concepts and some thoughts on discovery. First of all, is it did somebody internally raise the issue or externally? A lot of organizations have hotlines that are posted and published publicly, right, on the website. You might have patients and their families coming in and out of your organization. Those are the types of sources that I call external. They're not employees of the organization. They're external to the organization. Internal would be your employees and maybe contractors and vendors and those sorts of individuals. You also could have external discovery, unfortunately, by proactive enforcement agencies. So if a RAC or if the MAC, these are Medicare contracted entities that are contracted to run data analytics and those sorts of things, the OIG, those can also be external discovery. And so you might have an incident beginning from getting a letter from the OIG. They might have evidence already, or they might just be doing a routine audit of some kind or some sort of investigation. Okay. Another thing that's important to note is whether the source is anonymous versus known. If it's known, and you know who's bringing the concern to you. Many times I would leave a meeting and the doctor would stop me in the hallway and they'd say, because I'd built a relationship of trust as a compliance officer or a compliance professional with that physician, they would stop me and they would say, I have concerns about X, Y, Z. So that's a known source. Why is that important? Well, because from those first few slides that I shared, sometimes known sources that report internally can report externally. So you're not only dealing with the issue that got reported, you're also dealing with the reporter or the person who discovered that. So you want to make sure, and this is on the right part of the slide, the updates. When I say both up and down, what I mean by that is you want to make sure you're giving appropriate updates to the person who brought you the issue. If they bring you an issue in January and they never hear from you again until December, and then let's say they leave the organization or they're fired for other reasons, they might file a whistleblower lawsuit. So you want to make sure that you're, without inappropriately sharing details that informant, so to speak, is sharing with you. You don't want to share all the details of your investigation, but you want to keep them in the loop to say, thank you for what you've done. We are looking into this. We are in the process of, investigating or corrective action. High-level kind of updates, and that's what I mean by the down, is the person who reported it up to you, you need to make sure you're reporting back down. The third bullet on the left, proactive versus reactive. So a lot of times when we think of incident management, we think of reactive. a hotline call comes in, somebody stops us in the hallway, an audit's being done, so we're reacting to some sort of announcement or action that's being taken. But have we stopped to think about proactive discovery? What I mean by this is when an employee leaves an organization, many of us do exit interviews. It's really important that during that exit interview process, you have a few questions to say, you know, were you aware of any wrongdoing that you didn't report? Were you aware of any, practices that were not appropriate? These exit interviews are a great opportunity for a compliance program to be proactive and to find and to discover on their own. Another example is in employee performance reviews. So very mature compliance programs often tie into performance reviews some sort of compliance metric. So if you're a director of a department, your bonus or a part of your bonus might depend on how quickly your department completed their compliance training, and those sorts of things. So during the performance review, which in most organizations is an annual activity, you can throw in questions and you can proactively seek out if anyone has any concerns. Okay, so that's what I mean by that. Non-retaliation is a very important concept to share when we're talking about discovery. It's very, very important that your compliance program has a non-retaliation policy, meaning if somebody brings something forth in good faith, so they're not just trying to cause problems for you, but they're doing it in good faith, there has to be an absolute non-retaliation policy. It might cause trouble for their boss, for others with authority, but your organization cannot retaliate against those individuals. So it needs to be clear that whether the source is anonymous or known, that you are immediately telling that source, thank you for coming forward. Please know that we have a strict non-retaliation policy. Here's the policy, a link or whatever, because you want to hear if there's any retaliation going on, because that can have a separate cause of action legally, irregardless of what happens with the incident. Maybe it turns out to not be a true billing error or that sort of thing. If there is retaliation, that can be a legal action that the employee can take as well. Confidentiality is really important. People are coming to you in trust, and though you might not be able to promise, be careful not to promise that you're going to not tell anybody, because you do work for the organization and you may have to tell certain people. You want to reassure folks that you're going to keep it as confidential as possible. Because some of the folks the first time they come to you, they're learning how you're going to react and how you're going to treat them. Maybe that first concern they raise doesn't turn out to be a major concern, but 2 years down the road, they're going to remember that experience, and if there's a real issue, they want to make sure that they know you're going to treat it with confidentiality. Triage. Now, hopefully we're not getting so many, but it was like when I was in compliance, these things came in spurts. So for some reason, I'd get 7 in a week. And so that's why we're going to talk about how to track those and bring them to resolution. But you want to triage things. So you want to do some sort of quick assessment to make sure, okay, this could sink the ship. This might just put a dent in the front part of the ship. Not that you want to ignore or push away any of them. You want to fully resolve all of the concerns raised, but you need to prioritize and triage. The initial fact-finding is important in that triage process, as well as leading to this next bullet of attorney privilege. There may be some instances where in the initial fact-finding, you're already starting to get that tingly feeling that somebody may have done something illegal. That you're probably going to want to involve an attorney very quickly, versus an incident where it may have been a billing error. So it doesn't appear that there was any malintent. It was an honest error. We still have to pay those back and resolve the issue, but that might not require attorney-client privilege. And then the last bullet on the right is the ticking clock. So we've all heard the recent final rule, and we here at Healthicity did a webinar on this topic of the 60-day repayment rule. When it comes to overpayments, you have 60 days, and they've published a final rule, and you can go back and listen to this webinar. But that ticking clock brings something into this discovery area, where as soon as you're alerted, that clock has started ticking. So you got to be cognizant of that and be pretty quick. So here's some more on that. The 60-day time period begins when either the reasonable diligence is completed, okay, or, and this is the important part, or on the day the person received credible information of a potential overpayment, yada, yada, yada. What I want to share with you in this next slide is a legal case where a whistleblower brought a case and based on the failure to return overpayments within 60 days. The government intervened in this case, went to court, the U.S. District Court commented on what it meant to identify an overpayment, which I'm equating with that clock starts ticking, okay? They said when a provider is put on notice of a potential overpayment rather than the moment when an overpayment is conclusively ascertained. What does that all mean? Well, it might be the hallway conversation. You know, I'm a biller. Oh, you know, radiation oncology department is doing this, and I know it because I've been billing here for 20 years. We never did it. You know, on October 1st, they started doing this, and all those bills are false. If that can be deemed as credible information, your clock starts ticking then, as opposed to when a lot of us think of, well, okay, so I hear from them, I need to go in and actually have to look at it and find out if it really was an overpayment or not. What this court ruling was saying is, no, it's when you get credible information. And specifically in this case, it was this email that was received. And not to get in too much of the details, but essentially this Mr. Kane was the one who sent this email. And the key phrase that the court focused in on is, we've enlarged here, but it's from the email. It's when this individual in the email says, this gives some insight to the magnitude of the issue. So they were still very early in the discovery phase. They were just learning about the issue, and this may have been, I believe it was a couple days after the initial meeting, and this gentleman sent with an attachment that had an Excel file that showed potentially the universe of claims that were of concern. And the fact that he used this language, this gives some insight to the magnitude of the issue, that was this credible evidence, and that's when the clock started ticking, and they didn't get it done in 60 days, and thus the lawsuit. So some more on discovery. So, you know, in compliance, we're often pulling from many sources. So that was a legal case. Let's go. We all know that many compliance elements, the 7 elements, are derived from the federal sentencing guidelines. So what do the federal sentencing guidelines have to say about discovery? One interesting question that the guidelines ask is this: did the compliance program identify the issue before an external or other body did? So this is a key metric and in either case, you're going to have to resolve the issue. I'm not saying that determines whether you pay attention to it. This is a metric that can help you identify if your compliance program is becoming more and more effective. So did your compliance program identify the issue, or were you alerted to the issue because the state Medicaid office sent you a letter? If over time, if you're identifying more and more issues and less are coming from an external body, that's a pretty good sign that your program's maturing and getting better over time. Another really good source when it comes to discovery are corporate integrity agreements, and we're going to talk a little bit later about a corporate integrity agreement. A CIA is kind of the ultimate form of corrective action. And in recent CIAs, I've been noticing some language in there about disclosure programs. And this really has to do with, it's another way to say, kind of discovery and logging these discovery issues. So some of the requirements from a CIA as it relates to disclosure programs is, one, it has to be appropriately publicized. So this kind of goes to our proactive measures of discovery, which is, are you appropriately publicizing it? Emails? Are there posters in areas of the hospital or the office that are common areas? Does the disclosure program enable any individual to report? Does people without computers? There are people that work in hospitals that don't have a computer assigned to them. What if they're housekeeping? And so are there do they have a way to report concerns? And then preliminary good faith inquiry into the allegations set forth in every disclosure to ensure all the information is obtained, which is necessary to determine whether a further review should be conducted. So this kind of goes into that initial fact finding, and are you really doing a good faith inquiry, or are you just trying to like go through the motions, all right? So going back to the good example that we started off with, what was involved in their discovery phase? So their issue had to do with hyperbaric oxygen therapy and provider-based reimbursement. We all know there's a whole bunch of rules about provider-based reimbursement, meaning you have to meet certain requirements to be reimbursed as a hospital. Some of these are supervision requirements. So the initial hyperbaric oxygen treatment contract was from 2007, and it was a 5-year contract. And the way they discovered this issue is, so 2007, the initial contract is signed, but a few years later, the hospital had implemented a more formal contracting kind of review process, and they were using a contract management system to help them say, okay, these are all our existing contracts. When they come up for renewal, we need to make sure we're doing our due diligence. And what happened is their new system required legal and compliance and risk management to review all these contracts. That was not a requirement back in 2007. So when the new contract was being negotiated, the compliance department reviewed this contract with these provider-based regulations in mind. Okay, so that was a good improvement that their compliance program had made on the contracting process. It then led to this particular contract being reviewed with the requirements in mind. That's how it was discovered. Okay, so I want to share that with you. Now let's move on to investigation phase. Not all incidents are going to require an investigation. Okay, and that's what the OIG is telling us. Depending upon the nature of the alleged violations, an internal investigation will probably include interviews and a review of relevant documents. Some should consider engaging outside counsel, auditors, or healthcare experts to assist. So not all of us have the bandwidth in our compliance programs to go right from an incident discovery to an investigation. Sometimes you're going to have to reach out to either legal counsel or experts like ourselves to help out with some of these things, okay? You want to be considering a response team of compliance, audit, maybe billing folks, people that can help you get to the bottom of the incident. Thoroughness is an important concept, and then promptness. You want to be able to show, after all is said and done, you want to be able to show you acted promptly, okay? Here's some things to keep in mind when you go out and you actually have investigators. I've worked for compliance departments that we actually had a full-time person who was trained in performing investigations. These are skills, and not everyone has these skills. You want to make sure you have as many facts as possible before interviewing. You want to become an expert as quickly as possible before interviewing. So I recall an incident that had to do with physical therapy, and though I have some background clinically and I understand things generally, I had to really dig deep in a day or two and start reading the regs that were revolving around a particular incident that was reported. So I tried to educate myself as quickly as possible. It's helpful to prepare a checklist of questions based on the person you're interviewing. Sometimes you might be interviewing a department head. Sometimes you might be interviewing the biller or the person who's inputting data. The questions might be slightly different. It's also good to have the person show you. So if the person raised an issue, have them show you. Instead of asking a bunch of questions, just say, well, show me how this came about. And you go to the physical location. Well, yeah, I was looking at the medication pantry here, and it was unlocked, and this and that, and so they're actually showing you. Or they might show you how they came to the data, or how they found the paper record. Have them walk you through it. Avoid yes-no questions. Use more open-ended questions so you can get to more of the truth, and they can offer and volunteer some of that. Repeat what you're being told so you're clarifying. You know, if you're having a conversation and you repeat something and you say it wrong, that person is usually going to say, no, that's not what I meant. And that repeating can help clarify the situation, and it can really draw nice boundaries around your investigation, because you don't want to make the investigation bigger than it needs to be. You also don't want to make it smaller than it has to be, but it can help you draw some nice clear lines. And then you want to focus on facts. Don't draw conclusions yet. Okay, investigations, you're fact finding, and you don't want to just jump to conclusions and say, oh yeah, that lady, she's crazy, so I'm not going to really listen to these concerns of hers. Well, even crazy people can identify stuff that was wrong. Okay, so investigations, instances of noncompliance must be determined on a case-by-case basis. There's not a nice, though we're discussing general principles here, how you approach a Stark violation or an anti-kickback issue is going to be a lot different than how you're going to approach a billing issue, okay, or a credentialing issue. So just keep that in mind. And root causes, this is a concept that we don't have a lot of time to talk about today, but keep it in the back of your mind because it's a real good segue from while you're doing the investigation, you're going to move into the corrective action phase. You may have different people on staff that do that for you, but you want to make sure that you're really getting to the true root cause. Was it a computer error? Was it the person who entered something in the computer? You want to get to the root cause so that you can make good corrective action. So back to our case study of how we think things should go. In their investigation phase, this is what happened. After their discovery, so after the contract review discovered the issue, an immediate investigation was started. I like that word immediate. They did it right away. They didn't wait a week. It was confirmed certain aspects of arrangement did not meet those provider-based requirements. Okay, so they kept it focused on that provider-based issue. They determined it was a billing issue only, not a patient care issue. So there's no allegations that patient care was compromised or that poor patient care was given or that people were hurt because of this. It was all a kind of behind the scenes issue of billing, okay? And that's good to kind of draw boundaries around what the issue is. The look back period included the entire term of the agreement, okay, that original contract. And it included an analysis of whether there was some sort of careless disregard or deliberate ignorance. Why did they focus on that? Or was this just an honest mistake in the contract? Or was there some sort of careless disregard, meaning whoever drew up the contract or the business people involved knew that those regulations were kind of out there, but they closed their ears and eyes to it and then just moved forward. That could be determined to be careless disregard or deliberate ignorance, which then could have some criminal and some severe civil implications with the False Claims Act or the civil monetary penalties laws. And then they went about to self-disclose and they cooperated with the OIG. So that's a big decision to make, is this self-disclosure. It's not done lightly. It shouldn't be done lightly, at least, and you're going to want to have competent legal counsel. But it's a way to say, look, yep, we screwed up. We made a mistake. We found it on our own. We know we have to pay certain things back, but don't sink our whole ship because of this one mistake. We'll make it right. So the other thing to think about, and this is again the segue into corrective action, are corrective action plans developed that take into account the root causes of each potential violation. So as we move into this third portion of the presentation with corrective action, when you're doing that, are you looking at the root cause? Corrective action should not be, let's save the world type attitude and correct everything under the sun. You don't have the time or resources to do that. When it comes to incident management, you want to focus on what was the root cause of this particular incident. If your investigation raises other concerns, you want to note those, maybe put those in your annual work plan, your annual audit plan, other things that you can proactively go and do later, but you want to really take care of the incident at hand. And to do that, you have to drill down and find the root cause. So let's talk about corrective action now, our third step of the process. Some reminder language from the OIG. I think this is a great quote. Detected but uncorrected misconduct can seriously endanger the mission, reputation, and legal status of the organization. So detection, or our discovery and investigation phase, is an important part. But they say, but if you don't correct it, it almost may have been better not to detect it in the first place. So if you detect something, you gotta correct it. Okay, do the right thing. From the federal sentencing guidelines, they say the organization shall take reasonable steps to respond appropriately, including making any necessary modifications to the organization's compliance and ethics program. So it's appropriate to, a compliance program is supposed to mature over time. It's appropriate to make corrections, to say, you know what, our compliance program missed that. Here's how we're going to adjust so that we won't miss it a year from now. Those are the types of evidences and documentation that you want to have in your back pocket so you can ultimately demonstrate your compliance program is effective. So one of the things when we're talking about root causes, and again, this is not meant to be a root cause analysis webinar, but I wanted just to introduce you to some resources that are available for this. In the very first bad example that I gave you with that hospital and that physician who was doing stent procedures, in the legal documents, the government cited the QAPI program, QAPI. It's a quality improvement program in clinical care that many of us know about. But the QAPI has, and I've provided at the very end of the presentation, a link to this resource. But I just wanted to bring up kind of their paradigm or framework when it comes to root cause analysis. It's 7 steps. And these are basic principles. These principles can be used in compliance. They can be used in, quality of medicine administration or quality of wound care management. So it's not the widget that we're talking about, it's the process that we're talking about. First is identify the event that needs to be investigated and gather preliminary information. But you want to make sure you're narrowing it to identify the actual event of concern. You don't want to say, I'm going to look at all billing in our hospital. You'll never finish that one, okay? You want to say, I want to look at the billing. Why did pharmacy overbill from October 1st to November 15th? Okay, you want to be specific. Second, you want to charter and select a team facilitator and team members. So though compliance may be overseeing the root cause analysis, you're going to have experts, probably IT folks, maybe like the example I just shared with pharmacy, maybe pharmacy folks that are going to help you understand the specifics. The third is describe what happened. So describe it in a way, you think you might know what happened, but describe it in a way that a layperson or a person not involved would understand what happened. 4 is identify the contributing factors. 5 is then you go and identify the root cause. Was it human error? Was it systems error? Was it environmental? We had a hurricane and it knocked this out and whatever it was. 6 is design and implement changes to eliminate that particular root cause. So if it was human error, maybe some of the corrective action is you train, and then you're going to audit them again in 3 months, and then you're going to audit them again in 6 months, and you're going to try to change human behavior. If it was a systems error, then you get your systems experts to help you identify and confirm that you've corrected it. And then you measure the success of the changes, meaning a lot of people think, I've done the corrective action, I'm done. No, there's one more step. You measure that has taken place. So it might be, when I had serious incidents, I would often then have that issue on my auditing work plan for at least the next 2 years, okay? Because I wanted to make sure it wasn't going to creep back up. So corrective action, now let's come back to the CIA. As I was mentioning, this is the ultimate corrective action plan. These are some of the concepts. If you haven't read some CIAs recently, these phrases and these concepts are in many of the more recent CIAs. I encourage you to go back and review some of these, because a CIA is the government's enforced corrective action plan on an organization that made some sort of misstep, and they want to make sure for the next 5 years, most of these corporate integrity agreements are 5 years, they want to make sure for the next 5 years that this organization does all of these things so that the bad thing that happened before won't happen again. Some of the concepts: independent review organizations. These are organizations like Health History that can do independent reviews, meaning we're not employed, or the IRO is not employed by the hospital, but they're engaged, they're hired to do some sort of independent review. Claims review, that can be done internally, okay? And each of these phrases or concepts has a page or two in the corporate integrity agreement. So we don't have time to go over those details, but I just wanted to alert you to some of the sections of current CIAs that you might want to go back and review on your own. And if you can't find them, I'm happy to help you out. Just email me. Arrangements review, this is a whole process that the OIG has put in corrective actions when it comes to interactions with physicians. And so arrangements review is a good thing to review if you're looking at anti-kickback issues or Stark and those sorts of things. Validation reviews, and then risk assessment and internal review process. These are all good processes that are spelled out in corrective action agreements, or corporate integrity agreements, excuse me. So what was the corrective action in our case study of Lady of the Lourdes Memorial Hospital? So what they did, after they did their discovery, after their investigation, confirmed their concerns, what did they do? Immediate bill hold. That means, okay, we see that there's a leak. We're going to put a stop to that leak. Okay, or in my terms of training as an MD, when you have a trauma and somebody's bleeding, you want to stop the bleeding. So you stop the hemorrhaging. They put a bill hold on the services for any services on or after the date of discovery. Okay, and they went back to that date of discovery. The second bullet, identified alternate treatment arrangements for patients. They ceased the current treatment service agreement because the current service agreement was what was causing the problem with the billing. It was that contract. So they put a stop to that, and they identified an alternative way to get that service done for patients. Okay. Then they did a financial analysis of the overpayment, and they explained their rationale to the OIG. Okay. This is how we came about. We looked at our universe. We chose the beginning date was the beginning date of the contract, and the end date was our bill hold. Everything in between those two bookends, that is what our financial analysis will show. And then they go through and they explain the steps they took, and then they made the final settlement agreement with the OIG in October of 2014. Now, I probably should have mentioned earlier, a lot of where I'm getting the information on these slides, an individual from this actual hospital presented this case at a conference, and so I was reviewing those slides. So there's probably a lot more behind the scenes. I'm just kind of giving you a summary. So all of that led to what we started with in our good example was this statement that I've already read, that Lady of the Lourdes should be commended for the manner in which they handled the disclosure. Okay, now let's talk about documentation. You can have done all three of those things really well, but if you don't document all of those things that you did, 4 years from now, no one's going to believe you did those things, right? The default is to believe you didn't do them unless you can demonstrate you did do them, and the way you do that is through documentation. So again, I'm pulling from 3 different sources, and then I'll give you a summary slide. But the 3 sources I'm pulling from are CIA, the OIG, and there's one more we'll get to. But from a CIA requirement, let's look at what they say about documentation. You shall record each disclosure in the disclosure log. Now, my bias is that you use some sort of electronic tool to help you do this. It can be done on an Excel file or piece of paper and a pencil, but there's more sophisticated ways to do that. They're saying you shall record it in your disclosure log within 2 business days of receipt of the disclosure. Okay, the disclosure log shall then include a summary of each disclosure received, whether it was anonymous or not. Remember, back in our discovery slide, we talked about, was it anonymous? What was the source? The status of the respective internal reviews. So where are you? Are you just beginning? Or have you pulled the report? Have you asked IT to run this query? What are the details there? And then also any corrective action taken in response to the internal reviews. So that was from a CIA. This is from the final rule in the 60-day overpayment final rule. This is what they talk about when it comes to documentation. Providers should maintain records that accurately and fully document their investigation efforts to demonstrate that they acted in a diligent and timely manner. This is our opportunity as compliance programs to show what we did. We get to paint the picture. Do we want the picture to be painted with just one page in the file, or do we want to be, so in other words, when we're documenting what we've done, we want to be cognizant that somebody is going to be reading this in 6 years. Okay, that hopefully that'll never actually happen, but you want to be able to have documented and written this down so that if somebody's going to go back later and pull it out, they'll see, oh, yeah, that Wolf guy, he thought about that, he thought about that. Oh, clearly, I see he did this. You want to be able to paint the picture clearly. They, excuse me, they say it also to demonstrate that they acted in a diligent and timely manner. At a minimum, these records should set out what steps were taken to determine whether an overpayment existed, including all audits conducted, who was involved in the determination, names of people, titles, the outcome of the determination, and any follow-up or corrective action taken as a result. The third area, the third source was the OIG itself. They say records of the investigation should contain documentation of the alleged violation, a description of the investigative process, copies of interview notes and key documents, a log of the witnesses interviewed and the documents reviewed, the results of the investigation, and any disciplinary action taken and the corrective action implemented. So one more here. It is suggested that any communication resulting in the finding of non-compliant conduct be documented in the compliance files by including the date of incident, the name of the reporting party, name of the person responsible for taking action, and then the follow-up action that was taken. So in summary, I tried to summarize what those previous 4 slides were saying. Some key points. Log it quickly. They arbitrarily chose 2 business days. That's probably a pretty good measure. A summary of each entry and the source, persons involved, copies of notes and records, okay, status of investigation, corrective action taken, and disciplinary action taken. So those are the 4 major steps, okay? Discovery, investigation, corrective action, and the documentation, okay? We're going to open it up now for some questions, and just give me a moment as we look at some of these. So let me take this first one. It asks, you mentioned root causes in the QAPI program. Are there other resources that are available for root cause analysis? And the answer to that is yes. If I could, let me go to this last slide. I advance here. Okay. Here we go. So here are some other examples. I told you that I would give you the link for the QAPI. It's there at the top. And then there are other paradigms and other examples of root cause analysis. AHRQ, the VA, that's the Veterans Affairs, and then the JC, which is the Joint Commission. So these other paradigms that also you could maybe use to help you think about root cause analysis. Here's a question: how can we reduce external reporting, and how can we improve internal reporting? That's a great question. I wish I had all the answers on that one. I think the way that you do that is you create a culture of trust with the compliance program is one of the main things. Because you're spot on, your question is spot on. That's really what ultimately we want to do is kind of encourage this internal reporting. I think what's helped in some cases is a little bit of internal publicity. You got to be careful how you do this, but it really builds confidence in the compliance program when people see that disciplinary action's been taken. You don't have to, announce it and send an email out to everybody, but word can spread through the grapevine pretty quickly. An example that I'll share is, we had a physician that was not really following the billing rules the way they should have. We followed a very thoughtful process. We did audits, education. So we went through a pretty exhaustive process of trying to correct that behavior. It didn't get corrected, and the person was eventually fired. and for appropriate reasons, in my opinion. But the fact that was kind of known in the department, everyone else kind of shaped up, and it encouraged and it engendered trust in the compliance program, and people became a little bit. They saw that the compliance program meant what it said. In other words, it was just not a paper program. So that's one way, is to have some sort of show that the compliance program meant something. I think the other way is that you take those concerns seriously. When people report them, you treat them with respect, and you treat them quickly, and you give feedback, so that if the guys or gals are sitting around the watering hole in the break room, and somebody says, yeah, I once shared something with compliance and I never heard back, right? So versus you want the word on the street, so to speak, to be, no, compliance responds, and they got back to me. I told them on Monday, they got back to me on Tuesday or Wednesday that they're aware of the issue. It may take some time to investigate and this sort of thing, but they got back to me. I felt heard. Okay, that's a really good way. This question about the 60 days, does it vary from state to state? No, the 60 days is a federal rule, so you might have some state requirements, but the 60-day repayment rule that I was referring to was it's the federal government in regards to Medicare and Medicaid, and there's a whole final rule on that. As I mentioned, we've done a webinar on that before, and if you want more details on that one, you might want to rewatch that or download the slide deck. But that is not a state to state; it's a federal for all healthcare. What is the best way to determine an appropriate look-back period? That's a really good question too. So in some cases, it's told to us what that should be. So in the final rule for that 60-day payment period, they say to look back 6 years. There may be instances where the way I like to do it, and it comes back to finding that root cause. So there was a scenario that I dealt with that somebody had put in the automated, a lot of organizations have these billing edit systems, so they scrub the claims and the bills before they go out and before they go to the payer. The issue was a modifier was being appended at that step. Well, in that case, I wanted to go back and find out what's the day that somebody changed in the system, in other words, pushed a key on the computer pad and said, yep, add that modifier, because that's my start date. So you want that root cause analysis is really important to answer your question about how far back to look. You want to find that ground zero. Where did it start? Then I usually will involve our legal counsel to find out, okay, because what if that was 20 years ago? Okay. I might not be required, or it may not be necessary to go back that far, and you want to get competent legal counsel to do that sort of thing. Here's a question. What is the best practice when conducting an interview of someone who has been accused of misconduct? Should you advise the person of the specific allegations and ask, did it happen, or is it better to ask what the person's practice is in a given scenario? The concern is protecting the identity of the reporter while getting needed information from the accused. Yeah, those are excellent questions, and what you focused in on there is good interviewing and interrogation process, right, essentially. And that is a skill that can be learned. You can take courses in training, and the best way to do that. If I'm interviewing the person that was accused, because I've done that before, I usually start off with just having them explain the process. I don't want them to be defensive from the get-go. I usually say, and it's an art, so I'm not saying there's one right way to do it, but as you have experience with this, you kind of figure out what's worked and not worked in the past. But I had an example where we had a director, and there was a billing allegation from somebody that reported up to that director, And so I just went in and I said, can you explain the process? You know, I've been asked to look at this. Sometimes if I don't want to tip them off, I'll say, look, we're doing part of our regular review. This is not uncommon as a compliance program. We look at all areas that have potential risk, and then I have them explain that. And then I try, if that doesn't jive with some of the things that I had prepared, then I can go directly into saying, well, I ran a report on that, and this is what it was. And so then you share those different conflicting responses, and you try to have them explain that. That's why on that slide that I was talking about in the investigation phase, becoming an expert as quickly as possible is really helpful, and do as much fact-finding before you go interview somebody as you can. You know, some people say, you know, never ask a question that you don't know the answer to. And there is some truth to that, I think, that you ask somebody about how they do the billing process, but I already know because I had IT pull the bills for the last, 3 months, and I can kind of figure out what the billing process is. So that can give you a good idea of whether this person's going to be forthcoming or not. And then if you have made that decision, you kind of hit a fork in the road, and then you can kind of treat them a certain way. So that's a good question. How can you help us in reviewing an implemented compliance program? Well, that's a great question. You might want to email me. We do services where we do what are called compliance program effectiveness reviews, which is, as an outside party, it's good. Most compliance programs, and the government expects you to do a compliance program effectiveness review annually. A lot of times you can do the first year, second year yourself. But when you're hitting that third and fourth year, it really is best practice in the industry to have an external eye or an external body come in and do that. I'm a former compliance officer. I've done compliance program effectiveness reviews. So what I would recommend is that you contact us offline via email, and I can share with you how to do the compliance program effectiveness review. Maybe we'll end with this one. It asks, does self-disclosure and or self-identifying overpayments put you on a watch list in which you are more closely scrutinized going forward? It can if you are having them over and over and over again. A really good example of that is the OCR, the Office for Civil Rights, on HIPAA enforcement. You'll see some of these recent settlements that they've had have been brought about because the same entity has self-disclosed 3 and 4 and 5 times, and sometimes on the same issue. So what does that tell you? They didn't follow step number 3, which is corrective action. They keep identifying it and they keep reporting it, which I guess is good, but you missed a step, which is corrective action. Corrective action means you've actually corrected the problem. That's not to say we're not going to make mistakes in new areas. I think where it could put you on a watch list is if you're making the same mistake over and over and over again. However, I have found that when I've worked with like local Medicare contractors and I've told them, look, I've identified this issue, we start to have a better relationship of trust. They start trusting me when I tell them, yeah, it's only limited to 2 months and it was this one doctor. They start to believe me because I've been as open as I can. Now, I don't want to put my organization at complete risk, but if you are constantly telling people, or not constantly, but if you're occasionally showing that you've identified an area and you're doing repayments, I think that shows you have a strong compliance program, because no one in their right mind expects you to be perfect. So I do think kind of the repayment area, it's good to have a few of those on record to show that your compliance program is working, but you do want to be careful. If it's the same issue over and over again, you better correct it. Because you're going to self-disclose those and you're going to look kind of silly. So really great questions. If you have other questions that we weren't able to get to, feel free to email me. And I'm going to turn the time back over to Justin.
All right, well, thanks for the great presentation, CJ, and thanks to everyone for attending today's webinar. If you have any additional questions, please direct them to CJ at cj.wolf@healthicity.com. If we weren't able to answer questions during the presentation, we invite you to subscribe to the Healthicity blog, where we will answer your questions in upcoming blog posts. We just launched a poll that you should be able to see on your screen now. If you would, please rate how informative this webinar was on a scale of 1 to 5, 5 being the best. These polls help us improve our webinars, and we greatly appreciate your feedback. And one more time, we will be emailing everyone with an on-demand recording of this presentation, as well as the link to download the slide deck. So just to keep an eye out on your inbox. And thanks again.